Hello, my name is Darin Thompson. I'm from the British Columbia Ministry of Justice, and I'll be talking to you today about online dispute resolution and some of the other technology-related innovations we're working on here in British Columbia. Most of the technologies and the processes that I'm going to show you today will be built initially for the Civil Resolution Tribunal. This is a tribunal that will handle small claims disputes and strata property disputes, which in British Columbia is the name we give to condominium law, and it will open its doors in 2015 sometime, so we're still working towards implementation. We have passed some milestones already, including the passage of the Civil Resolution Tribunal Act in 2012, which authorizes the creation of the tribunal, and it also made online dispute resolution part of the body of law in British Columbia. Here's an overview of the Civil Resolution Tribunal process. It will help to contextualize some of the technology-based processes that I'll show you in just a few minutes. As you can see, it's a multi-step or a multi-phase process. It begins with problem diagnosis and self-help. I'll show you some of the technologies that we're designing to help people try to resolve their dispute early with the least amount of time and cost and effort and so on. But if these tools don't help resolve the dispute, it can be escalated into the party-to-party negotiation phase. Again, we're using technology to help support this process by providing some of the structure and the virtual space to host this negotiation between the parties. We don't expect a high resolution rate here, but we do know that some cases are always on the verge of settlement, and this is a way to try and address some of those cases. If that doesn't work to resolve the entire dispute, it goes into the case management phase. The first thing that happens there is a facilitative or a mediation-like phase where by now we have a case manager who works for the tribunal coming on with the parties and trying to see if he or she can assist with a resolution. If that isn't successful, then the case management activities turn toward preparing the dispute for a hearing. So these activities might involve things like making sure all the information is in order and making sure the issues are well defined and so on. After that, we can go to an adjudication. A tribunal member can come on and make a decision to resolve the dispute and make orders to give effect to that decision. Those decisions and orders can then be filed and enforced with the courts. We're working on some new processes and some new technologies to help make that filing and enforcement process a little more efficient and easier for users. From a system design and a technology design perspective, what we're trying to do is focus on using technologies to share as much of the load as possible, and this is what the ribbon at the bottom of the screen represents. Is in the early phases of the Civil Resolution Tribunal process, we expect to see the highest case volumes. This is one of the areas where we think technology can help to share that load by providing a lot of the services, by reducing the need for human resources to have hands-on time with those cases and to avoid all of the usual procedural log jams that can create. In turn, we think that the technology-based processes will be much more efficient and more sustainable and will provide much quicker service for users who want to attempt to resolve their dispute before it gets any bigger than it needs to be. As we move through the rest of this presentation and look at some of the technologies that we're developing, you will get a sense of how we expect some of these processes to work. So I'd like to show you now some of the technology that we're developing for the tribunal. I'm going to be basing these next few screens on conceptual designs. Conceptual designs just represent the ideas and various progressions of what we think the platform will look like and what it will do. You'll see two different versions mixed together. Some of them are grayscale. They're largely black and white. Those represent earlier designs. Because our development work has been going on for a few years, we also have some newer designs. These ones you can spot there, use more color. They're usually cleaner looking. In all cases, please don't worry about trying to read the text. On the screens, we tend to not focus too much on the text, but more focus on what kind of information needs to be displayed and what sort of functions need to be happening underneath that. So let's look at the first phase of the dispute resolution process. This is something that we call the Solution Explorer. It's an internet-based system that will help the user with some of those problem diagnosis and self-help functions. This screen would just provide an overview of what to expect for the user as they begin to use the system. Once they've had that introduction, they can move into a self-diagnosis or self-identification of the general problem or dispute type that they're facing. And you may not be able to read it, but this screen has a collection of different types of disputes that do align with the jurisdiction of the Civil Resolution Tribunal. In this newer or more up-to-date conceptual design screenshot, we can see what it will look like for the user once they move along into the Solution Explorer system. You may notice that the main purpose of this screen is to ask the user a question and to encourage them to select the best answer that aligns with their problem or dispute. This is how we move users through the Solution Explorer. It's the form of a smart questionnaire. The questionnaires are based on questions pulled from the system's knowledge base, and this knowledge base was created by going out and interviewing different subject matter experts who work in the domain covered by, in our case, the Civil Resolution Tribunal. So we would go out and talk to strata property or condominium law experts, and we talk to lawyers who are experts in the area of small claims disputes. As the user selects the answers, the system then decides what to do next. In many cases, it's going to be showing them another question. These questions will help to narrow down or diagnose the type of dispute to whatever level we choose to diagnose it. And then it can also then turn to providing very specific information to the user. And it can also move into providing other resources, which we'll look at in some of the next screens. I'll also point out on this screen, you'll see there's a progress bar in the middle, just below the top, 1/3. That tells the user where they are in the system. On the left-hand side, you'll see there's a way to track the user's journey through the system. There's an alphanumeric access code that the user can keep track of, so if they have to leave the system to go and do something else or go and collect more information, they can come back later and pick up where they left off. This next screen just shows that we've built in functionality in the system so that where it's necessary, the user can pick more than one answer, in which case then the Solution Explorer remembers that it has to walk the user down each of those particular pathways or those problems and explore them each in turn to the end. Because we move people through these Solution Explorer pathways in a very linear way, the prospect of opening up multiple answers and multiple pathways became very challenging for us. Luckily, we were able to overcome it and better reflect the reality of disputes, which often involves more than one problem or issue. This screen is just meant to represent that on the right-hand side, we can expose the user to some extra help or support. If they click the help button, it will show some of the commonly asked questions specific to that question and answer screen. The user can indicate whether or not the answer was helpful or answered their question. The system will then remember that for subsequent users and choose whether or not to display the same information or to try something else. This is a very, very simple way to help the system become smarter about what information people need the more times those questions are asked and answered. This is another type of screen that shows a resource we can make available to users. In this case, if our subject matter experts tell us that at a certain point in the Solution Explorer pathway, it would be helpful to offer the user a collection of tips or strategies, maybe to manage the dispute or help to resolve it on their own, we can make those resources available. This example that you're looking at here is a checklist for things a user can do in the context of a strata property dispute. So the user can decide whether or not to print a copy for themselves, or they can download a copy to their computer, or they can just say they'd like to continue, and the system will actually save that resource for them and present it at the end. We know that people have different levels of literacy, and some people, although they are fully literate, have different ways of absorbing or understanding information. So it was important to us to also build in the possibility of showing multimedia or videos and other types of resources such as this. Again, the user is free to watch the video at this point, but the system will also again remember this resource and present it to them again at the end of the Solution Explorer pathway. This is an example of what we expect to be a very common type of resource in the Solution Explorer. This is a letter template. So the letter template can be designed with the assistance of a subject matter expert, so it can contain very, very customized content that's specific to that dispute and specific to our user's role in that dispute. And this letter can be used in a number of different ways. In most cases, we expect it'll be used to alert the other parties or people in the dispute to the problem or the nature of the problem, maybe to provide some very detailed and helpful information about it, and also to propose some solutions or some next steps. The user might actually print this template off and use it as a letter. They might copy and paste it into an email to send to the other party, or they can simply use it for reference as a script if they want to have a telephone conversation or if an in-person conversation with the other party. In terms of the general approach, this is meant to be a very action-oriented tool to encourage the user to try and resolve the dispute at a very early stage before they engage more resources or engage the tribunal in a more formal way. Once the user has completed their exploration through the Solution Explorer system, they arrive at the end and are presented with the summary report. I'm sorry that the text on this screen is very small and probably too difficult to read, so I'll just explain what's displayed here. The most important thing is it's a record of any of the claims that were identified as the user moved through the system. So if they only identified one, that's all that would be contained, but if they had one of those multiple select screens, then they might have more than one claim, and the information that I'll tell you about now would apply for each. The main content would be a very natural language but very content-specific summary of what the user said they were experiencing. It would reflect on the type of problem that the user appeared to have, and it would outline some options that the user could then consider in terms of taking some action. Wherever it's possible, we try to identify more than one option. We try to rely on our experts to tell us what maybe the most common option or the most successful guidance that we can provide in any of these areas. In addition, the summary report records and presents to the user links to any of those resources that we showed them. So again, earlier if we showed the user a checklist or a tip sheet, and we showed them a video, and we showed them a letter template, those would all be gathered and collected here on the summary report for the user to go back and use as many times and at any time that they wanted to use them. The last thing is more of a streaming function that we find on the report that basically says to the user, if you're unwilling or unable to resolve this dispute on your own outside of the system, then you can take the next step and move into the next phase, in this case of the Civil Resolution Tribunal, which would be the party-to-party negotiation phase. So it would prepare the user for payment of a fee, tell them what information they'll need to do to complete that next step, and all they would have to do is click the button and start that next process. I'll move very quickly through the rest of these screens, which all show the Dispute Resolution Suite, which is a part of the system that can be used separately from the Solution Explorer. If we imagine that our user completed the Solution Explorer and they've now escalated their dispute into the next phase, the first screen that they might see would just show them their options for proceeding. They can select an online resolution method where they would be using a web-based platform that could be used on a computer or a tablet or a smartphone. They would log into it. It would provide the richest experience for them. It would also be the most efficient service for us to deliver from the tribunal's perspective. But they can also select an offline resolution process. This does include things like email. It also includes telephone options. It also can include paper-based documents in the ordinary mail. In terms of a design perspective and making the online tribunal easy to implement, we knew that it was very important to make multiple channels available and to make online and offline options available for people who for one reason or another are unwilling or unable to use the internet-based technology. We think this is a critical piece for going forward with online dispute resolution in the civil justice context, and that is addressing those people, again, who are either unwilling or unable to use technology. It becomes an extra challenge to find a way to make these multiple service channels, as we call them, to these multiple channels available to people and still keep things moving smoothly, to keep the dispute resolution process moving quickly, and to not create too much of a burden from an administrative perspective. But we think that we've designed a platform that can effectively pull these channels together and accomplish all of these goals, while again appealing to the broadest number of users with varying levels of technical ability. So moving along, the user might be asked to put in their name and contact details, as well as the details for the other party. They might be taken through a specific screen to ask some very focused or specialized questions designed to flag issues like whether the dispute has already been resolved somewhere else, or whether there's special circumstances like violence between the parties, or anything else that the tribunal staff might want to know about this particular file. In this screen, the user will be asked to frame up their dispute in such a way that they can move into the negotiation process with the other party or parties. They're certainly allowed to add some customized content, to say some specific things, to make some specific demands, to upload evidence, and include other types of a detailed description. But what's very, very important here from a design perspective is on the right-hand side of this screen, we are publishing or pushing forward the user's results from their Solution Explorer work that they did. So we don't want that work or that effort that they put into that first phase to be wasted. So we've designed it in such a way that it pushes the information forward into this phase. In fact, that happens throughout all of the phases that we've designed. Is everything that's created in a prior step is carried forward into the subsequent step. This is a way to build momentum and to keep refining the dispute resolution process, to keep narrowing the issues, and so on. The only area where this doesn't apply is when a dispute is moving from the collaborative phases into the hearing phase or the adjudicative phase, in which case special efforts are taken to make sure that none of the settlement discussions are brought forward into that adjudicative phase. Here we see a notice package that the system has prepared for the user. This is where we start to tie all of these different technologies and technology-based processes into the justice processes that might be more familiar to many of us. In this case, we're giving the user the option to give notice of the dispute to another party by any number of different channels. The first thing they can do if they want is try and notify the user by email. The notice by way of email will only count as effective notice if the other party receiving that notice comes on to the system and acknowledges receipt. If acknowledgement doesn't happen within a certain period of time, then our user has to escalate to the next level, the next method for giving notice, which may involve printing off this customized document and sending it by way of registered mail or delivering it in person. In this screen, we see that the system is bringing to the user's attention that notice has not yet been provided to all the parties. So as long as it's recorded in the proper way in the system, the technology can actually keep track of what has happened, what hasn't happened, and what needs to happen next. So it comes very close to building the procedural rules right into the system. And in a way that saves the users from having to read all of those rules in a separate document and try and figure out how they apply to their particular circumstances. Once the other parties have been engaged, the negotiation process might begin. This would be a way to keep track of those communications back and forth. The users can initiate new communications and send them through the system or through one of those other channels available to them. They can respond to a request through the system in the same way you might respond to an email. They can upload evidence and other documents, provided it's in a digital format. It will send it right up into the system and be kept in that case file, at least in a virtual sense. With some very simple tools like calendars, the system can also help to automatically track where the user is in the process, how long the current process should take, and what they should expect to happen next. For any issues or claims the parties are able to resolve, they can sign it off and create the agreement right in the platform. If the parties are unable to resolve their dispute by agreement, then they can prepare it for their hearing. The presumption is that a lot of this work will happen through the virtual service channels, and it will be the equivalent to doing a trial on the documents, although in this case the documents will largely be in electronic form. Although I want to make clear that at least as far as the Civil Resolution Tribunal is concerned, the tribunal members and case managers have absolute discretion to hold a telephone-based teleconference. They can arrange for a video conference. They can have documents sent back and forth through mail. They can even arrange for an in-person meeting if they think the case requires, although we think that will be quite rare. But the presumption again is that the technology-based channels will be used wherever possible, and they can be mixed with any of those other channels, all within the context of the same dispute. In this case, we can see that the user is preparing their claim for the hearing. They are shown the original claim information on one side and the original evidence, and they are left to select what then is going to be pushed through, what's going to form the basis of their position or their documents as they move into that adjudicative phase. As I mentioned earlier, we've designed some different screens and some different processes to ensure wherever possible that the content of settlement discussions are not carried forward into the adjudication process. Very briefly, I'll show you some of the caseworker views that happen behind the scenes. We can include dashboards so that case managers can get a sense of what their current workload is and what case types they have in the process. At any time, they can also go in and view not only the names of all the parties or representatives involved in the dispute, but they can also see which communication channels those people have identified as their best way to exchange information and so on. Again, everything from telephone to email to the web portal to paper documents and so on. Case managers and adjudicators can also schedule specific events. Again, if they were going to hold a teleconference during the process and so on, they would schedule it in the system and it would send out notifications to the parties based on the channel that that person had selected, again, whether it was web portal or email or another means. Lastly, we're also developing dashboards to be used by someone like a tribunal chair or a chief judge of a court, where at any time he or she can go in and see the current breakdown based on case types or where they are in the process. They can see what the trends are over a set period of time. For example, this example in the screen shows a 6-month trend. They can see the current caseload and the distribution of the cases across different parts of the dispute resolution process. They can instantly see the names of all of the active cases, who the case is being assigned to, if it's being assigned to someone else, and so on. So a tremendously powerful way to collect, aggregate, and display information, and keep in mind it will all be shown in real time. From an administration of justice perspective, this is where we can start to get really excited about new ways to manage performance, or to get a sense of how well the justice system is working, or what kind of load our civil justice system is under, when we can have this kind of up-to-date or up-to-the-minute information available through a dashboard like this. So this is the end of my presentation. I want to thank you for watching it. Thank you for your interest in some of the technology and the innovations that we're working on. I'll arrange to make my contact information available if you do have any questions or want to continue the discussion. I'd be very pleased to do that. So once again, thank you very much for listening.